this is a little bit of a non-traditional podium, but I don't think I can do this while sitting down in front of everybody. So, in anticipation of my California Golden Bears reclaiming the axe from a certain school down the road this coming weekend, my client, T6 Networks, requests that the judges give the axe to Mr. Doe's two untenable damages theories that he's presented in this case. We bring this challenge not to his qualifications, but to his methodology. As I'll explain in a moment, the methodology behind both of his opinions is inadequate because the opinions are not grounded in the facts of this case. As a result, they're speculative and reportedly mislead the jury. So why don't we start with the first of those opinions, which is something called the Nash theorem. The basic argument against the Nash theorem is that it's a laboratory concept, something from the ivory tower, that has no application in the real world in a court of law. So, the Federal Circuit Court of Appeals has recently rejected the Nash theorem. And I'm not going to bore you with too much of this, but the main point here is that they point out that the theorem follows from a certain set of premises. It itself asserts nothing about what situations in the real world would fit those premises. And anyone seeking to invoke the theorem as applicable must establish that fit. So to put it another way, the point here is that even though damages analysis necessarily occurs in a but-for world, that but-for world has to be tied and grounded in reality. And failing to do that means that the opinion falls short of the standard required by Daubert in federal court or Sargon in California courts. So, with that qualification, that question in mind, you've got to ask yourself, does the Nash theorem actually predict anything about real-world outcomes? The answer to that from Mr. Doe's mouth himself is no. Why don't we take a listen to some deposition testimony?
Let's talk about the broader economic community. You consider yourself a member of that community?
Yes.
The economic community has never accepted the Nash bargaining solution as an accurate predictor of actual outcomes. Do you agree with that?
I think I'd have to agree with that, yeah.
So, full stop, that should be it. The Nash argument should be excluded. Now, if your honors need anything further, the federal court here, the Northern District of California, has repeatedly excluded application of the Nash theorem of litigation. Judge Alsop, in typically colorful language, said the Nash bargaining solution would invite miscarriage of justice by clothing a 50% assumption in an impenetrable facade of mathematics. Now, not to pander too much, but Judge Graywall also rejected a 50-50 royalty split for failing to tailor the royalty rate to specific facts of the case, including the particular technology, industry, or party.
I find that particular citation irrefutable.
So, that should end the inquiry as to Nash. Now, if you'd like to delve deeper into Mr. Doe's attempt to actually apply the Nash theorem in this case, that also fails for two separate reasons. The first is that he improperly fails to divide the economic surplus. So here's where we kind of go down the rabbit hole a little bit. The Nash theorem, to take a step back, focuses on how to divide the surplus. What that means is the difference between the benefit of cooperating versus the next best alternative if the parties didn't cooperate. So let me give you an example from real life. So let's say my 6-year-old daughter has a lemonade stand, and she's selling lemonade on the roadside, 25 cents a glass. And Mr. Stern has a client who claims that my daughter's lemonade recipe violates his client's trade secrets. So Mr. Stern, as he very well might do, writes a cease and desist letter. She receives it, and then we end up in litigation. And so Mr. Stern's damages expert couldn't even count up the number of orders that my daughter collected from selling lemonade and say, hey, 50-50, half of that is my client's. That's not the way you do it. You have to take that total amount that she made selling lemonade and subtract out the best available alternative. So, say for example, selling fruit punch. So the expert takes the amount made selling lemonade, subtracts out the amount that she would have made if she sold fruit punch instead, and what's left is called the economic surplus. And it's to that that the Nash theorem applies. So the problem in this case is that Mr. Doe failed to make an effort actually to calculate that surplus. What he did instead was to rely on testimony from the plaintiff. So here you see, did you see any testimony from anybody other than the plaintiff in the case that came to the same conclusion that the trade secrets were important when hiring Mr. Boyd? The answer, I recall some emails. I don't recall the specifics of them now. So you can't identify any documents. Question, so no testimony that you're aware of. Answer, no, nothing that I'm aware of, nothing that I can point to as I sit here today. So that kind of begs the question. If the idea in calculating the surplus is to take what the defendant actually made and to subtract out of it what the defendant would have made in the next best alternative, how in the world would the plaintiff know that? The plaintiff, of all people, is going to be ill-suited to say what the defendant would have done in that circumstance. So, getting into the details, that's one reason why Nash fails here. Another reason that it can't be applied before the jury in this case is that, as the Federal Circuit mentioned, the Nash theorem applies in only very specific circumstances. You have to show certain premises have been satisfied. Here's a way to think about it. Think of the Nash solution as a combination line. And the 50-50 split that the plaintiffs all love, that's the bottom tumbler. That doesn't matter until you go through the first two tumblers above, as we all know from doing a combination line. You're not going to do the third one until you do the first and the second, right? So here, the two top tumblers are perfect information and perfect rationality. What perfect information means, again, showing you that the Nash theorem is just that, a theorem. It doesn't have any application in the real world. It means that the parties actually know perfectly what's in one another's minds when they enter the negotiation. Perfect rationality, similarly, many of us have negotiated for a new car or for a house. We know that there is no perfect rationality in real world negotiation, but the theorem requires it. It requires there to be perfectly rational behavior by both parties participating in the negotiation. So the solution is limited. Mr. Doe himself agrees with these two assumptions. The assumption of perfect rationality and perfect knowledge of each other. Needless to say, we would submit that there's no negotiation in the world in which those two premises would be satisfied by, and so as a result, you can't apply the Nash theorem if you split. So that's the discussion as to Nash. He has another damages theory in which he would take 1.5% of the value of my client's company, T6. And the reason that he would do that, now I'm sure all of you have committed the hypothetical to memory by now, but just in case you haven't, the reason he would do that is that back in 2003, 11 years ago, the plaintiff received an offer from a different company, a small company, startup, for 1.5% of that company's early pre-IPO options. My client went public in 2010, very successful company. He would take 1.5% of this public company's market cap as a proxy. He doesn't provide any basis for this. And there are two fundamental problems with that approach. The first is that these companies are in different fields. The company that extended this offer 11 years ago was a networking company. And that's where the relevant technology, what it actually pertains to. My client's company is a network security company. Different field, they do different things. I asked Mr. Doe about this in his deposition. Here's what he had to say.
I know you're not a technical expert, but you'd agree that network security is different than networking, wouldn't you?
Well, they both rely on the network.
So, that's the level of depth of thought that Mr. Doe is putting into the comparison. But the second, perhaps more fundamental point, is that there's no basis in which to consider a multinational corporation that's had a successful IPO a couple of years ago and say that that's comparable to an early stage startup pre-IPO. The best that I can think of, that's like saying that when you buy a lottery ticket before the Powerball drawing, the expected value of that ticket is equivalent to the ticket that actually wins after the drawing, when all the risk has been eliminated and the outcome is certain. That's pretty much the circumstance here. T6, my client, is a successful public company. It's attained its success through the hard work over many years of its employees. Much of the risk relating to that venture has now been eliminated by the market. In contrast, the comparison that Mr. Doe would apply is at a much, much earlier stage where there's still enormous risk to the value of the options. So, for those two reasons, we would ask that Your Honors exclude Mr. Doe's opinion, and in closing, go Bears.